You can proceed. Good.
Good afternoon, Your Honor. We're seeking to compel plaintiffs to produce 3 categories of documents here. And first, before I get started, I wanted to ask how you would like to proceed. I can go through all 3 categories, or I could go category by category, and we could go back and forth. Give a preference.
Category by category.
All right. So, Your Honor, the first category of documents that we're seeking to compel from Ben Abbott is basically his keyword bidding data, and that is in requests 8 through 12 in our motion, as well as his call center scripts, or his the scripts that he uses when a client first potentially reaches out to him and calls him. The reason why we're seeking this information, Your Honor, is because this is a case in which Ben Abbott has alleged that my client, Angel Reyes, when he bids on Ben Abbott's name as a keyword search engine keyword, and that when he does that bidding and somebody searches for Ben Abbott, Angel Reyes bids on that name, and Angel Reyes's advertisements appear, that those advertisements are confusing, misleading, infringing, tortious, and a whole lot of other wrongful things. And it's our position, Your Honor, that that Ben Abbott's keyword bidding is also relevant, both to liability and because Angel Reyes has a affirmative defense of unclean hands. And I first would like to talk about our unclean hands defense, and then in turn talk about why that information is relevant to liability. With respect to unclean hands, it's our position that Ben Abbott engages in the exact same conduct, or substantially similar conduct, as what he's alleging is wrongful. And by that, we know that Ben Abbott has bid on at least in one instance, Angel Reyes's name. And we know that because it has come up in Angel Reyes's own search engine auction insights. And we believe that Abbott has, to some extent, bid on other attorneys' names as well. And we want to seek discovery on that, because to the extent that he engages in the same bidding behavior, which then leads to similar online advertisements, which again, we believe that the online advertisements for Ben Abbott are very similar to those of Angel Reyes. Abbott makes allegations that certain statements that Mr. Reyes makes in his online advertisements, saying things like he's a 5-star injury attorney, or that he's recovered millions for his clients. We believe that Abbott makes substantially similar statements. For example, that he's the #1 winningest attorney in Texas. And so we want to seek discovery to find out the extent that he is engaged in the same conduct that he's alleging as wrongful here. And it seems to me that based on plaintiff's response, that the rub is that they don't believe that they seem to potentially agree that Abbott's bidding behavior on Reyes is relevant, although they haven't agreed to produce that. But they don't agree that Ben Abbott's bidding on other attorneys would fall under the unclean hands doctrine, and we disagree. And Your Honor, there's a case that I found this morning as I was going through plaintiff's response, and I wanted to show it to the court. Unfortunately, I did not find it in time to put it in our reply, but I did want to share my screen if Your Honor would allow it, so that I can show this case, because I think it it's controlling of this issue and how courts treat the unclean hands defense in the advertising of advertising and Lanham Act type claims of trademark infringement and false advertising. And while I certainly understand that plaintiff has not brought their claims under the Lanham Act and they've done common law, it's very clear that the issues under common law Texas trademark analysis mirror that of the federal standard. So I'd like to share my screen to show this case. And the case number, Your Honor, is 273 F sub 2D 817. And it is Health Point Limited versus Ethics Corporation. And it's from the Western District of Texas, San Antonio Division. And Your Honor, I found this case because the plaintiff relies on a Dallas Court of Appeals case, Condom Sense, in their brief. And Condom Sense is a 2012, like I said, Dallas case that cites favorably back to this case as for the proposition that unclean hands does apply to Lanham Act trademark infringement cases. So I'm going to skip down to the section in which this court discusses unclean hands. And I've highlighted just the particularly relevant analysis in this case, where the court looks at how courts have treated unclean hands with respect to advertising claims and trademark infringement. And it states that equity denies relief where the plaintiff is misrepresenting to the public the nature of his product, either by the trademark itself or by his label. And it cites to a United States Supreme Court case that says, when the owner of a trademark applies for an injunction to restrain the defendant from injuring his property by making false representations to the public, it is essential that plaintiff should not, in his trademark or in his advertisements and business, be himself guilty of any false or misleading representations. If the plaintiff makes any material false statement in connection with property which he seeks to protect, he loses his right to claim the assistance of a court of equity. And ultimately, the court in this case goes through numerous cases from other jurisdictions where courts have considered and either applied unclean hands or in some cases chosen not to apply unclean hands. And I wanted to also highlight this case that it discusses because I think that the facts are analogous to the ones here. And this is the Haagen-Dazs versus Frusen Gladgy Limited. And that citation is 493 F sub 73 in Southern District of New York, 1980 case. And it discusses a case in which Haagen-Dazs was the plaintiff and they sued the defendant for infringement and basically claiming that the defendant had marketed their ice cream as if it was from Sweden and therefore kind of infringed or made it look similar to Haagen-Dazs' own packaging when it was really a product in the United States. And the court there applied the unclean hands doctrine because it found that Haagen-Dazs also marketed its ice cream in a way that was likely to make consumers believe that it was from Scandinavia when it was also a domestic product. And it's very similar to the unclean hands argument that we're making here. And ultimately, after the court, the Western District of Texas looked at all these cases, it came to this conclusion, Your Honor. It says, these cases show that a plaintiff's product will not be protected if plaintiff's own unclean acts regarding the product can deceive the public or are essentially the same conduct of which plaintiff is complaining. And I'll stop the screen share. And so, Your Honor, that's the argument that we're making here is that to the extent that Abbott engages in the very same conduct that he alleges is wrongful, both in the sense of keyword bidding, but also in what his advertisements, the resulting advertisements look like, the types of statements that he makes, we should at least be entitled to discover to what extent he engages in that conduct. With respect, Your Honor, to liability.
Response?
Your Honor, I think counsel may have one other point to make on this first set of discovery. I can respond to just unclean hands if you'd like.
Go ahead.
So basically, Your Honor, just to give you the 1 minute overview, again, what this case is about, if I could share my screen, I'd like to, if we're going to be talking about relevance and that kind of thing, I'd like to give you a 1 minute recap. This is what this case is about. This right here, okay? When someone goes on their mobile phone and searches for Ben Abbott and Associates, this ad comes up, okay? This ad for Reyes, all right? And in big letters, it has call 855, the number, right? And it's a click to call ad, right? And it may be a little bit small on your screen there, but that's intentional because that's how it's going to be on somebody's phone when they search this, right? They search Ben Abbott and Associates, they see this, they think, well, look, that's the number. And so they call that number, okay? They click on it, actually. It doesn't go to Reyes' website. It prompts your phone to actually call the number, right? So they call the number, and we have recordings now of this. Someone at Reyes' offices answered and said, 5-star injury lawyer. And a lot of the people, we now have actual recordings of this, say, is this Ben Abbott and Associates? Or I'd like to speak to Ben Abbott, right? And the person on the other end of the phone says, well, this is actually Angel Reyes, but we also help accident victims. You know, can we help you? And so what we're talking about here is initial interest confusion. Okay, people are confused by Reyes placing these advertisements using Ben Abbott and Associates as keywords, our trademark as keywords to place these advertisements. Okay, they actually said in testimony that 1/3 of all the calls that they get in response to this ad, somebody asks for Ben Abbott or somebody like Ben Abbott, you know, or is this Ben Abbott's office, right? And so Reyes then uses this initial interest confusion, which is actionable, to try to sell the person while they're on the phone, right? You can use us instead. We're really good, right? We have actual recordings of this now. Ben Abbott does not currently place these type of Google ads on anybody, any law firm or firm name, okay? It's 2022. It is true that in 2019, they did do this for a short period of time. They did place some ads on Angel Reyes and Associates in 2019. That's 3 years ago, okay? The reason why Ben Abbott and Associates brought this case is because these ads right here are ongoing today. And Reyes is not going to stop doing it. So we had to bring this case to try to make them stop, essentially. Before I jump to the unclean hands thing, I do want to make note of the fact that Reyes has brought this motion to compel, but it is still not complied with the court's November 2021 order that it produced certain documents by December 1st. It has produced some documents, but we're still waiting on some of those. This is months later. The court's already ordered them to produce them by December 1st. And so I don't think the court should grant them any relief on a motion to compel until they comply with that. But to get to this first category of documents, one thing I want to show you, Judge, I don't know if you got the courtesy copies. Your Honor, I think you might.
I have them.
Okay. One thing I want to point out in their motion, and I guess if I'm still sharing my screen here, this is their motion, for example. You know, this is what they purport to be their requests. This is page 5 of their motion. They list a bunch of the requests. Okay, these are not the actual requests. These are limited versions of the requests. If you look at our response, for example, request number 9, this is what they say is the request. Okay, that's not the actual request. The actual request says, for each online advertisement placed on behalf of Abbott. Right, so this is they're asking for every single online advertisement that Ben Abbott has ever placed. Same thing with all of these. They've taken out the very first beginning part where it starts with for each advertisement placed on behalf of Abbott. Okay, they've taken that out when they've represented their request. Okay, and the reason they've done that is because that's a ridiculous preface, right? For every single online advertisement for Ben Abbott, even at best, this case doesn't have to do with every single online advertisement by Ben Abbott. Same thing with their representation of what their request number 34 is. Okay, they say it's call scripts and other documents related to Abbott's intake processes. That's not what it actually says, right? What it actually says is scripts, interview outlines, other documents or forms used by Abbott during client intake process during the relevant time period, including but not limited to documents that purport to describe general procedures and practices, et cetera, right? Okay, so that's a misrepresentation of what they're actually asking for. And I think the reason they did that is because they know on their face, those requests are extremely overbroad, okay? But just to back up, this case, so they're asking for documents having to do with all of Ben Abbott Associates online advertising. Okay, this case, number one, it's not about Ben Abbott's advertising, right? They have no claim. They have asserted no claim against Ben Abbott and Associates for advertising issues. Okay, but second of all, this case isn't even about all of Reyes's online advertising. It is about a specific set of advertisements that Reyes runs on Google using Ben Abbott's trademarks as keywords. Okay, that's what we look at. This is what this case is about. Not Reyes advertising generally, certainly not Ben Abbott's advertising. It's just these specific advertisements that use Ben Abbott's keywords to place these ads. Now, one thing I would like to make a point of is also, we asked them about their other advertising activities, okay? And in deposition, their corporate representative says, I'm not going to answer any questions about our other advertising campaigns, our other keyword bidding, anything like that, right? They produced some documents where things have been blacked out. You know, they did say in their deposition, sure, we run a bunch of keyword campaigns. Ben Abbott, we got others, but I'm not going to tell you anything about any of those others. On advice of counsel, in the deposition, I'm not going to answer your question about our other advertising campaigns. And so it's a little bit strange to me that they would ask us for all of that information. That's inconsistent. You know, I don't quite understand how they can justify taking that inconsistent position. Second.
Okay, let me do this. So you guys have provided me an order that goes through the request for production. I think it's interrogatory number 4 and request for productions 1, 8, 9, 10, 11, 12, 14, 30, 31, 32, 33, 34, and 40I. Those are what we need to be talking about. Is that right?
Yes, Your Honor.
Right. So let me do this because I fear this could go really long. I appreciate the background. I'm going to just go ahead and rule on these, and then if there's a argument I need, I'll ask you guys. So, but I thank you for the background. For request for production number 1, I'm going to sustain the objection. Number 8.
Well, Your Honor.
I'm going to go ahead and rule, and then if I need argument, I'll ask you. Okay.
Yes, Your Honor.
Number 8. I'm going to sustain the objection. Number 9. I'm going to sustain the objection. Number 10. I'm going to sustain the objection. Number 11. I'm going to sustain the, I guess for number 11, is any of the argument here going to go to the issue of damages? Like, are you trying to get some of this stuff because of damages?
Yes, Your Honor. I would like to I think requests 8 through 12, and that's the keyword bidding data request. And so that does go to 11. I would just like to briefly address, because it's very important to injury and liability. And Your Honor, if you would just then allow me a brief moment to explain why. It's more than
brief.
Okay. So Your Honor, as an element of Abbott's burden of proof. He needs to show that he was injured by the activity that he alleges. And whether he was injured relates directly to how his performance in the auctions that he bid on, and that Abbott being able to compare the auctions that Abbott is in where Reyes did participate versus the auctions where Reyes did not participate, and whether that affects things like the price he paid, the placement, what kind of click rates he got. And I understand, Your Honor, that Abbott says, that's not my injury. My injury is that we lost clients or that you took my clients. But Your Honor, if we can show that he was not harmed, that he suffered no either financial harm and that he did not suffer any harm in his online advertising standing, that would be powerful evidence to rebut the argument that he does make on injury and say you did not.
I just don't see how any of these requests go. I understand that. I just don't see how any of these specific requests go to that particular issue. I agree with you. Like, if you can show the revenue associated with the particular that I'm trying to even think that Abbott got from a particular auction that it won versus an auction that it didn't win. But all of this goes way beyond that.
Your Honor, well, let me just briefly state it. I think that it also
maybe 11.
Your Honor, if I could chime in here.
Right.
I'd like to finish, just make my second point very briefly. Your Honor, we think that it also goes to secondary to other points in which Abbott bears the burden of proof, such as secondary meaning and the strength of his mark, being able to compare how much he both pays for and is willing to pay for it and bids on other people's names versus his own name. For example, if he's paying more and bidding more on other people's name than he is on his own, that just goes to show that in this space, his mark is not as valuable, is not as strong as comparatively speaking to his competitors. It would also go to show if he's bidding on other people's names and he's getting the same type of calls asking, say he's bidding on Jim Adler and people are clicking on his mark and calling to him and saying, are you Jim Adler? That just would go to show that his mark doesn't have the secondary meaning that he has to prove that it does. People don't automatically associate Ben Abbott with Ben Abbott. They are just as easily confused when he engages in this information or in this conduct as when they contend that what happens with Reyes.
Your Honor, if I could chime in.
Sure.
In response to those arguments, that's not what these requests ask for. Okay, that's just not what they say. Second of all, if it has to do with profits, we are not seeking lost profits or damages to Abbott in this case. Okay, in business competition and trademark cases, the law recognizes, look, it's hard to prove lost profits. Okay, so they let you recover the defendant's profits that they generated through the use of the trademark, right? That is what we've pled for. That is what we're seeking. Our injury is people being diverted, right? They've given us a list already of people who have called the number on the ad that I showed and that was placed in response to Ben Abbott and that they have signed up. Okay, is
that accurate?
I'm sorry, that we have
the last part that says that the damages that they're seeking are simply the amount that you diverted, not.
Well, they amended their petition, Your Honor. At the time that we filed this, they had allegations of things like loss of goodwill, like injury to reputation, and now they're seeking in their petition only the disgorgement and I think unjust enrichment of defendants' profits, which is true. But I will say, Your Honor, in trademark infringement cases, for monetary damages to be appropriate, they still have to show injury, and courts look, particularly in trademark infringement cases, and we included this in our reply, the courts look to see if there has been actual damage as an element of whether disgorgement is appropriate in the first place. So disgorgement is not an automatic does not automatically flow from liability with respect to trademark infringement. And so they will still have to show a compensable harm. And if we can show, so there's liability, and if we can show that they have not suffered any damage or financial harm, then disgorgement may not be appropriate for their trademark claim. And I'll also say that with respect to their tortious interference claim, the Texas Supreme Court has held that for tortious interference with a prospective contract, you have to show actual loss or damage. So they're only looking at certain claims, I think, and they need to show that as elements for other parts of their case.
The tortious interference would be the damages would be whatever contracts you tortiously interfered with and the value of those contracts, right?
They don't have contracts with these people, so I don't exactly know how they're going to value their damages on
well, it'd be tortious interference with prospective contracts, right?
Right. I would imagine that they're going to say.
Okay. So I'm going to go ahead and sustain the objections to 1, 8, 9, 10, 11, 12, 14. Let me go to 30. Sustain the objection 31. Thirty-one is sustained. 32. 32 is sustained. 33. 33 is sustained. 34. 34 is sustained in part. I'm going to allow you to get any scripts that refer to other law firms. So like, let's say it's, you have a script that says that you advertise with Jim Adler, and then they call them Jim Adler and they have Jim Adler in the script or Angel Reyes in the script. I will allow you to go into that. So scripts for other law firms.
Your Honor, with respect to requests 31 through 33, that's a separate category of documents that relates to something that we have not talked about yet. And so I would just like ask to be heard briefly on that as well.
All right, we're running out of time, but go ahead.
Okay, so the requests 31 through 33 relate to Abbott's tortious interference claim. He has to prove as part of that claim that there was a reasonable probability that anyone searching for his name, or that the people that he contends he lost had a reasonable probability of actually engaging him.
But why would it matter how many lawsuits Abbott filed?
Because, Your Honor, I think that how many people contact him versus how many people engage him, and then how many people he actually then files a lawsuit on. A lot of these firms will refer cases out, or they'll retain them and then reject the case. So
they still you have to understand, Ms. Adams, I was a personal injury attorney before I was a judge. I understand this industry pretty well, although I never worked for either of these firms. And we actually were the firm I worked for was one of the first advertisers. So I get the industry, and I get what you're saying, but there's not a direct correlation between the amount of money Ben Abbott makes isn't correlated necessarily to the lawsuits that are filed. It's how much is settlement income. And that brings me back to the whole idea of maybe conversion rates, like for each, if there's something that shows like for each, what percentage of clients, how much money was made on particular advertising or something, how many of these actually converted into clients. That's what the real issue is. And maybe that's asking a question that isn't objected to, but all this other stuff I think is really just a fishing expedition.
Well, Your Honor, that would be request with respect to the bidding data. I think that would have been request 11 to show impressions, clicks, and then conversions out of the people who see his ads, and then out of the people who click, and then how many people call. And then with respect to overall contacts, that would be at least 31 and 32. Okay, how many people contact you versus then how many people actually sign up with you? Like I said, he has a burden of proof.
If I may on this.
Look, I'll finish my sentence. He has a burden of proof to show that somebody who searches for him is reasonably likely to actually enter the contract with him. And he claims that that's not in dispute. They say that in their response, but that could not be further from the truth. We strongly dispute that somebody who simply enters a search term is not just shopping around. Or they claim that that person, if they entered Abbott, they must be wanting to engage Abbott. Our position is that person could be searching, they could be researching. There's a lot of different things that person could be doing that doesn't necessarily mean that they are ultimately going to engage Abbott. And that's what we're trying to seek discovery on, both with respect to what does the data show, but also what do Abbott's own numbers show with respect to his success rates in actually getting people to engage him, enter the contract that he must show.
Your Honor, the problem with that argument is that's not what these requests are asking for. Okay, it's not tied to Ben Abbott's bidding on Reyes's name in 2019, right? These requests ask for all of Ben Abbott's online advertisements. How many people contacted you, contacted Abbott across all channels, right? If you're looking at number 31, documents sufficient to show the number of potential clients that have contacted Abbott each year during the relevant time period. So somebody sees a TV commercial and contacts Abbott and they want to know about it. That's not what these requests ask for.
So does the conversion number 11, which I'm inclined to kind of maybe reverse myself on, does the conversion values of the advertisement, does that, I don't know exactly what goes into that. Does conversion value mean for each click, how much do you make off of the click, or kind of what does that mean exactly?
Your Honor, conversion, that's something in Google AdWords that you negotiate with Google, what you'll count as a conversion, right? Maybe you count a phone call connection as a conversion. Maybe you count them submitting your web form as a conversion. It's a subjective thing. But again, this would go to all of Abbott's online advertising, right? Not connected to the issues in this case. Not connected to
I do think that Ms. Adams makes a point that we do need, I agree that it shouldn't be all lawsuits ever filed, or that's way too broad, or how many clients do you have? Because I know Abbott does advertise in other ways, but I do think there needs to be, and you tell me, Ms. Adams, which request you believe gets most to this particular issue is how many for each time somebody clicks, how many clients come from that? And that's the issue, I think.
Right. And so I think, Your Honor, I think that request 11, which would get us the number of conversions, and we would be willing to limit 31 and 32, which is people contacting versus then people signing the engagement letters, to perhaps customers that came in through the search engine advertising channels, to the extent that they can determine those. I would imagine that they could. I think that would get us to that.
Your Honor, let me say, the issue with 11 is it's too vague, right? Clicks on what are they even talking about? The conversions when someone clicks on any Ben Abbott advertisement, I think that would not be relevant. If it was limited to advertisements that were placed in response to Reyes keywords, then maybe that would be relevant. But if Ben Abbott just runs an advertisement for Ben Abbott and someone clicks on it, the conversion rates on that are not relevant, right? The injury in this case is someone seeing Reyes's ad and clicking through on that, right? The injury is people being diverted.
But they have to make they have to take, they are taking the stance, Your Honor, and they've said this twice in their brief, that they claim that it's not in dispute, that when someone searches for Reyes, that they have a reasonable probability of engaging Reyes. Okay, so the claims that they're making are also not limited to just Reyes. They are making a very broad claim that when somebody enters the search term Abbott, that person intends to engage Abbott. And that's going to be a very central issue in this case that we're going to litigate, of whether that person intends to and is indeed likely to engage Abbott, and therefore is Reyes's advertisement showing up there also, is that tortious or is that interfering with a likely engagement?
All I like to say is if you're inclined to grant 11, it should be limited to Reyes bidding, and because if it has to do with all of Ben Abbott's online advertisements over the past 5 years, that's just, it's extreme, it's too broad. It has nothing to do with the case. They want to pretend like they have no idea why somebody searching Google would search Google for Ben Abbott. That person has no likelihood of hiring them, right? So then the question is, why do this bidding? Why pay $200 to place your ad, right? Because somebody does have a likelihood of wanting to engage Ben Abbott or a lawyer. You know, they can argue that they don't know why they would like to spend $200 per click on their Ben Abbott ad, but they do know. And so the issue is, I do agree, Your Honor, we do have to show injury in that clients were actually diverted. They've given us a list of those clients that they have signed up through their ad. I don't think this is really even in dispute.
Your Honor, that when he says
but your causes of action, Mr. Linyard, are broader than that, aren't they?
No, Your Honor, it is totally limited to the exact ad that I showed you. It is totally limited to Reyes using Ben Abbott keywords to place Google advertisement to divert clients. It has nothing to do with
the only damage you're seeking in this case is the disgorgement of profits from the clients that were diverted because of these Reyes, and there's nothing else.
Correct, Your Honor.
Your Honor, their third amendment petition has an entire section is called the false advertising scheme, where they allege that statements like 98% success rate, I'm reading from their petition, their live petition, millions recovered from clients, 5-star accident attorney. They are claiming a lot of different ads, and their support that they've pointed to for the millions recovered for clients and for some of these are actually TV scripts that Mr. Reyes submitted to the state bar. So they've requested a lot of discovery on other advertising statements and generalized statements that don't just simply appear in that particular click-to-call ad,
Honor,
or just a click-to-call ad.
Briefly, Your Honor, even with the false advertising issue, it is still limited to the Google advertisements that Reyes places by using Abbott keywords. That is the only practice at issue. Now, yes, we are complaining about two things about those types of ads, but that is the sole type of ad, and the sole damages we're seeking are the disgorgement of profits of clients that have been diverted through those Google keyword ads, and an injunction to stop Reyes from using Ben Abbott's trademarks as Google keywords. That's it. It is limited. It has nothing to do with all online advertising. It has nothing to do with all TV ads. It is extremely limited. And so that's our point here, is that what we're complaining about in this case is limited, and so their discovery should be limited.
Your Honor, I would just direct your attention just very briefly to the third amended petition, in which, if that's the only thing that's at case, why do they have an entire page screenshotting other types of advertisements
to show
by Reyes, and now claiming that the only thing at issue is a click-to-call ad?
Because what those screenshots show is that he knows that the things that are in the Google advertisement are false, right? He never submitted that small Google advertisement to the state bar. What he did, and that's what we're complaining about, is the small Google the keyword advertisement. What we did by putting that in the petition is show that Reyes knows those things are false, right? Because he has submitted other ads that the state bar has already told him he can't do that. right? We're not complaining about those TV commercials or seeking damages with respect to people who contact him through the commercials. We're only seeking damages with, like you said, Your Honor, people that have been diverted by these very specific Google keyword ads that Reyes places by using Abbott's.
All right. So what I'm going to do, I'm really kind of concerned about this because I want to make it so you guys can quote this to me later. I'm going to deny the motion to compel in its entirety based on the representation that the only damage that Ben Abbott is seeking is disgorgement of profits from the diverted clients that would have gone to, that allegedly would have gone to Ben Abbott, but for these Reyes ads, and that's all.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, anything else, guys?
Your Honor, we'll submit a confirming order if you.
I already got it.
Okay, all right, thank you.
Your Honor, do I
I want to make sure, Mr. Gerhard, your associate, I don't know if he's your associate or your partner, that seems to be, you're really limiting your damages here to avoid discovery. If that's not accurate, that's, and I want this on the record, Tony, then I would rule very differently if your damages.
No, we're not backing away from that, Your Honor. I mean, the point of this lawsuit is to disgorge those profits and stop this activity. We'll stand by that all the way through trial.
Okay.
Your Honor, just one question for clarification. Because your ruling is based on that representation, is it correct that should there be further amended petitions that might bring this back into question, that we could rebring the motion?
Absolutely.
Okay, thank you, Your Honor.
Okay, you guys are excused. Good to see you. Good job, both sides. McEwen versus Lewis, are both sides here on that? Anyone here, McEwen versus Lewis? Are you here on that, sir, Mr. Mann?
I am.
Okay. What's going on here? And who else is here on that?
Your Honor, Caitlin Kerr on behalf of the defendants, Sherry Gay Caps and Design Transportation Services.
Is that everyone on this case?
No, Your Honor.
Who else is on it?
It's a Sunoco Retail LLC.
Could you speak up, please?
Your Honor, I believe he said Sunoco Retail LLC and Derek Ray Lewis are represented by separate counsel.
And are they here on the call? I don't know who they are. There's someone named Bill, James Sauter, Nathan Schwartz. Is anyone else here on this case?
The attorney I would have expected, his name is Steve Comte.
He's not here. Does he have a dog in this fight?
Yes,
Yeah,
Your Honor.
he's the one who quashed all the depositions.
Well, that's strange. Do you want to call him and find out if he's going to join us?
Sure, we would like to do that. Caitlin, do you have any? We can, if you want to send us go to the next one, maybe Caitlin, if you have that number.
Oh, is Jim Callahan, is that it?
I don't believe so, Your Honor.
No, the attorneys are Steve Comte, and then there's also Kevin Yankowski. One of our associates that left is the one who had handled most of this, so I don't actually know if there's anybody else other than that.
Okay.
Your Honor, I can give Mr. Compte's office a quick call.
Okay, go ahead and give him a call.
Will do. Okay, Your Honor. I was able to get a hold of Mr. Compte, and apparently there was a misunderstanding. So the parties have another hearing set at 4 o'clock on a different motion. And I guess that he was under the impression that both of the hearings had been rearranged such that they would occur back to back at 4. So he said he is available and he should be on momentarily.
Okay, so you want to take care of this now?
He said that's fine. He said he'd be here in just 1 second.
Okay. All right, this hearing is supposed to end in about a minute. We're really swamped today. Okay, well, there's Mr. Compte.
Hi, Judge. Stephen Compte. Sorry I'm late. I've had it on my calendar for 4.
Okay.
That we had two separate hearings. I apologize for the confusion.
No worries. Okay, let's go on the record on DC 2018306. McEwen versus Lewis. Council, make your appearances.
Richard Mann, law offices of Ted Line and Associates for the plaintiff, for the McEwen plaintiffs.
Stephen Compte on behalf of defendants Sunoco and Derek Lewis.
And Caitlin Kerr on behalf of Design Transportation and Sherry Gay Caps.
And Judge, I spoke with Frank Whedon earlier today. He's Mr. Hammond's attorney. He's in depositions in another case and doesn't really have a dog in this fight. So he's just sitting this one out.
Okay. We don't have a ton of time because of the late start. So let's go through this quickly. What's going on? I see that there's a difference of opinion on when to schedule these depositions.
Your Honor, I can actually short circuit all of this. It's really simple. You made an instruction in a hearing on December 20th. I don't think Mr. Compte is going to tell you that you didn't make the instruction, but we didn't have an order. The instruction was simple. They blew their deadlines for their experts. We asked that they be stricken rather than grant a continuance. What you did at that hearing was split the baby. You said, all right, I'm not going to strike the experts, but I'll give you the continuance, but the plaintiff's going to go first. That instruction was not in an order. I have had a conversation with Mr. Compte. There's email communication that confirms that is exactly what happened. And the other attorneys aren't going to say that didn't happen. After that, Mr. Compte and I spoke, and we actually seemed to be on the same page, but he needed to confirm authority. When that happened, we came back and he was on a very different page and said he's not agreeing to it. So we said, all right, we're going to notice the depositions. Just give us dates. We're following the judge's instructions. We noticed them. He quashed them. We're here. That's what happened.
And Judge, I will disagree that there was no instruction given. What the court actually said, and I don't believe Mr. Mann was at that hearing. He may have been. I think it was Mr. Davis. The court said that what you sometimes do in this situation where we get additional time to designate experts is you may allow the plaintiffs to take the depositions of our experts first, but you specifically said this is not an order, it's not a ruling. I'm just telling you how I may deal with the issue if presented with it in the future. And I think if we pulled the transcript from that hearing, that's what the court would see.
That sounds like something I would say. I do say that.
And so that's the reason we're here, Judge, is we've reached that point where we do need that decision. Will there be an order that requires that? Now, the one thing that has changed since that hearing is we've amended the scheduling order completely to set the trial off into the fall, I believe, so that it's not an April trial setting anymore. I don't believe that there is a need for the plaintiffs to go first. They bear the burden of proof.
So, Mr. Compte, is the chronology correct that you guys blew your deadline and then I kind of gave you a chance to designate experts after that? It's in blunt terms, I don't think we blew the deadline, Judge. We designated in time. The court had suggested we do that and that you would potentially allow extra time for reports. So we designated our experts in time, but needed additional time for reports. We had submitted a motion to amend the scheduling order to allow extra time for reports. And you actually had signed that order at the time that we had the hearing. Now, it turns out, I think that you did sign that order by mistake because you thought it was agreed when it was not.
But so I wouldn't quite so bluntly say that we blew the deadline. It's just there was additional time needed for the reports due to some late disclosure of records by the plaintiff.
I respectfully disagree with that. Your Honor, the fact is this, their deadline was coming, filed an emergency motion, which we disagree. That hearing happened. What you instructed them is that you'd suggest that they designate. And so what they did is they, designated the names and the CVs, but no reports, then filed a subsequent motion for continuance. I was not at that hearing, but I talked to all three lawyers that were, and all three lawyers, including Steve Compte, said the same thing. And our email traffic is attached to our response. And it was this: you were giving them a second chance for, I called it blowing their deadlines, but the fact is there was a date, they missed it, and there was no good reason for it. So you split the baby. They've lost really nothing other than we get to go first in terms of taking their depositions, which was mild in comparison to, candidly, if we were just to follow the black letter rules.
All right, I'm going to order the depositions to take place. I guess I'll go ahead and make the order, which is you're going to need to provide your depositions first, Mr. Compte, and I don't. It looks like there's quite a few experts on both sides. You guys need to kind of get moving on this because continuances are harder and harder to get these days with COVID, so, or post-COVID, or whatever you want to call this period. So I would encourage you guys to get it done. So give me an order on that, Mr. Mann, and we'll go from there, okay?
Your Honor, may I say something just briefly?
Sure.
I think we just want to be clear. It was a joint motion. I was not a party to the other hearings, but I think we just want to be clear that if we are ordered, as you're suggesting, that we make our experts available first, that we will only, we're not going to agree to reproduce them a second time in the event that plaintiff wants to redepose them after their experts have been deposed.
We have no plans on that. That's not a problem.
Yeah, that's kind of standard. So, but that we would not. I rarely order a second deposition unless there's some kind of bad conduct. So, no, that's fine. But it also doesn't. This doesn't affect your experts unless you have the. Did you have the same situation where you guys didn't designate experts either?
Oh,
Kerr.
Your Honor, I believe that it was a joint motion for all defense experts.
Okay, this only addresses Mr. Compte's experts.
they're almost all the same, Your Honor.
Okay, then any experts that Mr. Compte late designated would need to be deposed first. So just make sure that's clear, okay?
Understood.
All right, anything else, guys? And Mr. Mann, when you present the order, go ahead and say at the beginning that it's going to be, that this was heard on April 4th, 2022. Share the order with Mr. Compte and Ms. Kerr to make sure that they don't have any issues with it. And I guess I will see you back at 4 o'clock. Is that right?
Hopefully we'll be able to agree, but if not, we'll see you then. And thank you, Your Honor.
Thank you, guys.
Thank you.
Thank you, Judge.
We have a hearing in the Jackson case, I believe, next. Tony, let's go on the record on DC 1913360, Jackson v. Preston Tower Condominium Association. Council, make your appearances.
Jim Sauter on behalf of Preston Tower Condominiums.
Bruce Steckler, personal counsel for Board President Leslie Warren.
Nathan Schwartz representing Mr. Jackson.
James Davis on behalf of Intercity Investments.
Christina Alstron on behalf of Intervenor.
Is that everyone today? We missing anybody? Okay, let's go ahead and proceed.
Your Honor, before we begin, I want to clarify or ask a question. Anyway, is Mr. Steckler here as counsel? Is he making an appearance in this matter, or is he still in the same capacity he was in last time he appeared, merely as an advisor to the court?
Well, I think that's a good question, Nathan. I will likely be in the case, and just for the court's clarification, Mr. Schwartz's client recently amended their complaint or petition, adding 22 defendants, including Ms. Warren. I'm not aware of service yet. I'm not aware whether their D&O insurance has been put on notice. Out of respect for all of that, I can't really make an appearance now in the case, but I am her personal counsel. And because this involves a protective order and specifically involves Ms. Warren, I do believe we have standing to speak and address the concerns with this court. And I think the impetus for this hearing probably has to do with the email I sent to the court and the concerns that I raised. And I'm happy to start it if that helps, Mr. Schwartz, or if you want to say your piece, I'm happy to handle it any way the court pleases.
Well, I think I think we want to at least lodge an objection and suggest that Mr. Steckler shouldn't be here in that capacity. His client was not a party prior to us amending our pleading last week. And if he's not here, if he's not making an appearance on her behalf as her attorney as a party, then I'm not sure why he should be here at all. And the fact that his letter, his email was the impetus for this hearing kind of underscores that he asked for this hearing at a time that his client really didn't have personal standing to seek it. And she already had counsel for her in her role as a representative of the board. So it seems extraneous.
Well, I'm not familiar in particular with what rule you're citing, Mr. Schwartz, but I'd be happy to address the court in the basis.
Mr. Steckler, you can go ahead and proceed.
My appearance. Thank you. This case, Your Honor, involves water damage to Mr. Jackson's apartment in Preston Towers. It occurred in 2018. Ms. Warren has been Preston Towers board president for less than a year. A few weeks ago, as recently discussed, Your Honor allowed me to express some concerns I had regarding the conduct of plaintiff David Jackson and the need for a more fulsome protective order. Mr. Jackson, unfortunately, has a pattern and practice of sending harassing emails to my client and other board members and witnesses. For example, as this court may recall, in one email he wrote, "You either have a death wish or are downright ignorant." In another one, he wrote, I'm sorry, what just popped up?
That's the protective order I think we're fighting over, right?
Oh, I believe that's correct. Hold on. I had my notes up on my computer. Let me see if I can. Yeah, I wrote some notes here. And he wrote, "When you go down in flames, remember you brought this on yourself when I seize your bank accounts, your properties, etc." We also know, Your Honor, that Chris Payne and Christina Alstron, who's on the call here, had to withdraw from representation because they found Mr. Jackson was insisting upon pursuing an objective that counsel considered, I want to be clear here, repugnant and imprudent. To stop this conduct, at our prior hearing, I'd suggested a more fulsome protective order that provided that communication simply be made through counsel for all parties. It would be reciprocal. It would comport with the spirit of the disciplinary rules and would not prejudice any party. It just seemed to make sense, and it would avoid what appears to be a pattern and practice of just outright harassment. It was my understanding the court was going to consider several options and edits. However, I think as a result of some recent conduct by Mr. Jackson, I think a strong protective order is now mandated for the following reasons. Since that hearing, Mr. Jackson's conduct has gotten worse. On March 21st, my client received a demand letter. You heard me, a demand letter from him. He is not a lawyer, which provides, and I'm going to quote, "I am currently representing Leonard Wenmos and myself in our combined $20,000 claim against you for the dog bite and slandering and disparaging my name, and also demanded my client's resignation from the board immediately. What's worse is my client received a text message from Mr. Wenmos, the putative dog bite victim, stating, "I'm not suing anyone over anything, especially a dog bite, and I'm not demanding any money." This was confirmed this morning by Ms. Alstrin, who is Mr. Wenham's real lawyer, who has a real law degree and license. But that didn't stop Mr. Jackson also from contacting every pet control agency in the city to harass my client. Mr. Jackson's conduct is threatening, it's inappropriate, and we all know it violates the Texas Penal Code. I think it's 38.123. When I raised my concerns about the demand letter to Mr. Schwartz and how I thought that this letter was definitely an affront to the protective order that we were seeking, the response I received was, quote, "I disagree the letter in any way violates the terms or spirit of the order." I suspect that they fail to recognize that the Texas disciplinary rules, I believe it's rule 5.05B, provides a lawyer shall not assist in the, or in this case, condone the unauthorized practice of law. And certainly this letter was threatening and harassing to my client. And now there's more, which we just talked about. Mr. Jackson has now filed a 7th amended petition in his 2018 water damage case in Preston Towers, adding 22 new parties, including my client, who joined the board in May of 2021. I don't know if amendment is allowed in the case at this time. As I said, I haven't yet appeared, but I do know that allegations of defamation and slander in this petition, based on a July 2020 letter, are time barred and constitute nothing more than harassment. Bottom line, Your Honor, Mr. Jackson has engaged in a pattern and practice of harassment. You have the emails. His prior counsel had to resign because he was insisting upon pursuing an objective that they consider repugnant and imprudent. And his current counsel cannot or will not stop him from the conduct. For that reason, I think now more than ever, we need a protective order in which Mr. Jackson and all the parties simply communicate through counsel. Whatever he needs, his counsel can direct it to my client's counsel, and they can work it out, and vice versa. It's just the best and safest way to avoid the level of confrontation, harassment, and just unnecessary crap, candidly, in this case, and we can focus on the underlying issues. And I urge the court to seriously consider this. The conduct is scary, it's inappropriate, and no lawyer would be tolerated to act this way. Thank you for allowing me this opportunity.
Mr. Schwartz, do you have any opposition to the protective order that's on the screen?
No, Your Honor, that's the one I think that we crafted after discussion with the other counsel. And our argument is that it works fine. So far, the one time we've actually, anybody's actually invoked it. And by the way, as you can see, it isn't signed yet. We've all been, or at least we have, for our part, advised Mr. Jackson and been conducting ourselves as if that order is already signed and in place because we had agreement. But the one time that it actually was invoked.
Let me ask this, and is there a different order that's been submitted that you want me to consider, Mr. Steckler?
Yes, Your Honor. I believe this order was limiting in nature, and my suggestions and edits were that all communications, no matter what, be conducted through counsel by all parties. I believe Mr. Souter had seen my edits. I believe Mrs. Alstrin also saw the same edits and joined me in that. And the proposal that we have before the court is not as fulsome as I thought would be necessary given the recent conduct.
So let me ask this, do I have a copy of this most recent one? Was it e-filed or?
I don't believe it was, Your Honor. I think there was some discussion back and forth between the parties, and I do not believe that all of those edits were captured in the version that was submitted to the court. I know in particular, interveners had requested that they be included as a party within the protective order, but the Booth Law Firm took the position that that was premature, as they had a pending motion to strike our petition to intervene. So I know, at least with respect to interveners edits, they were not included in the proposed order that was provided to the court. And I can't speak to Mr. Steckler's because I don't remember, but I do recall that I was in agreement with those, and I'm just not sure if those were also included in the proposed order to the court.
Does the court have a copy of the amended protective order, or who has that so I can look at it?
Your Honor, let me intervene real quick. And I'm in an awkward situation. I don't have filing rights at this point in time. My understanding from the court's direction was that you wanted multiple red lines and you were going to take a look at them and make some decisions. Mr. Souter actually at the time currently is representing Preston Towers Board. And I sent him my red lines and comments reflecting my concerns.
Mr. Souter, have you submitted that to the court?
No, Your Honor, I have not. Based on what Mr. Steckler is saying, we need to readdress what Mr. Steckler's concerns are. This order addresses communications solely as to the lawsuit, but the communications are
Is he frozen or am I?
He froze. And I think what he's saying is that I think what the suggestion is, this protective order only applies to this lawsuit. So the dog bite allegations would then be allowed, or allegations about anything outside of his pleadings would be permitted. That's exactly what we're trying to stop, is going beyond the plea. This is a case with parties that have a dispute, and I don't want there to be any misunderstanding, threats on side issues being brought in to pressure either parties or witnesses. And that was my concern originally, is I just felt like it needed to be broad, to just say, look, we don't need to have Mr. Jackson communicating with board members or witnesses. It's just not permissible, and it can all be done through counsel, and anything he needs with respect to his apartment or services, Mr. Schwartz can talk to Mr. Souter, whoever it may be, and they can effectuate that immediately, and vice versa. That's what I was looking for, and that was my hope, and this did not reflect that. Is that right, Jim?
That's correct.
Your Honor, may I respond?
Oh, Judge, you're on mute.
You're on mute.
Go ahead and just sign the order that's been submitted. And then at some point, if Ms. Alstrom or Mr. Steckler wants to submit a new order or an amended order or a proposed amended order or something, I'm happy to do that. But I feel like I need to get something in place. There's 50 problems, and this order may solve 40 of them. I don't want to keep waiting. If this is my only case, and I could sit around and twiddle my thumbs while you guys bring in extra, I'm not fussing with you, but I need to get something in place. And so let's get in place this particular order. And if there needs to be some kind of amendment to it, I'm happy to do that.
Thank you.
Honor.
Ms. Alstrom and I will submit a proposed amended order for the court's consideration. Would the court like it to be set for hearing, or will it just take it under advisement?
If it's not agreed to, then I would probably want to hear it on it.
Fair enough. We'll do that again.
All right. Thank you, guys.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor.
Thank you, Your Honor.